Hi, good morning, everybody. Thank you for joining. We'll just give it, I think, one more minute to let the stragglers come in, and then we'll start. Great. Well, I think we've got a quorum. We can let other people join as they come online. So good morning, good afternoon, good evening, everybody, depending on where in the world you're based. I'd like to say thank you all for joining us today. It's been a week full of some great sessions, so this panel appreciates you making the choice to join us today. The topic for today is hindsight. Is there an increasing reliance on the use of hindsight in valuations? If not, should there be as a result of COVID-19? I should let you know that this session is being recorded and a link will be sent out to everyone and it will be uploaded onto the HK website. Now, I may well be biased, but even without the benefit of hindsight, I'm confident that I can forecast that we'll have a great session on this topic. How can we not have such a stellar lineup of panelists? First, we have Anneliese. To save me the effort of pulling together an introduction for Anneliese, I've instead unashamedly plagiarized the words of others. Anneliese is recognized as a leading lawyer in her generation and a standout genius who is frequently instructed on high value and complex cases, both nationally and internationally. She is ranked both as a leading silk in 6 practice areas in the legal directories and as an arbitrator. In 2020, Anneliese won International Arbitration Silk of the Year, described as an absolute rock star at the top of the game. Anneliese is equally at home in a court or arbitration setting and also regularly appears at appellate level. It's hard for me to add anything to those amazing quotes and achievements. All I will say is that, to date, I'm very pleased not to have been cross-examined by her. Next, we're joined by James Rogers. James is a partner at Norton Fulbright's London office with a practice focused on international arbitration. He has a particularly international practice and has acted as counsel, advocate, and/or as arbitrator in proceedings under most of the international institutional rules in arbitrations all around the world. He has also practiced law in New Zealand, Hong Kong, and Japan, although Japan is the only jurisdiction in which he's not qualified. His experience extends across a broad range of industry sectors and includes corporate and commercial, technology, M&A, licensing, and joint venture disputes, but with particular experience in the energy, infrastructure, and construction sectors. He also has significant recent experience in arbitration matters involving states and state-controlled entities. One of the leading legal directories recently described him as flexible and extremely efficient. Now, I think his wife disagrees with that, but thankfully for him, she's not a client. Next up is my colleague, David Saunders. David is a partner in the London Forensic Accounting Commercial Damages practice of HKA. He's a chartered accountant with over 30 years of experience in forensic accounting. He's been appointed to act as an expert in more than 100 matters and has provided oral testimony both in court and international arbitration on 20 occasions. His expert work centers around quantification of damages and valuations, and his cases cover a wide range of industries. David is recognized annually as a leading expert in Who's Who Legal, with such fantastic comments as being a really excellent expert with an internationally renowned flair for valuations and quantification of damages, and I would highly recommend him. He is a formidable opponent. Now, I've been lucky enough to have worked with David for 15 years across 3 different firms. For a while, I wasn't sure who was stalking who, but I guess I got my answer when I moved to Australia and David didn't follow. Last, and as we can see from those introductions, very possibly least, my name is John Humphrey. I'm a partner at HKA, where I lead the forensic accounting and commercial damages practice in the Asia Pacific region. I act as an expert in both litigation and arbitration proceedings, assessing damages in matters requiring business valuations, and assessment of lost profits, consideration of accounting issues, and additional cost claims. I have a truly international practice. For example, I'm currently engaged on matters based in Australia, Singapore, India, the UK, Sweden, Turkey, Uzbekistan, Libya, and Dubai. Like my fellow panelists, I've been lucky enough to be recognized for my work. I'm included in a number of the Who's Who legal publications, where I have the pleasure of receiving quotes referring to me as Jonathan, John, and he. As we go along, we hope that questions arise which you'd like to put to the panel. Please can you submit those into the questions box, and we'll hopefully have time to go through those in the Q&A session at the end. Okay, so let's kick off this session and talk about hindsight. Now, the approach to hindsight depends on the claim being advanced. For breach of contract claims such as loss of profits, it's generally accepted that you look at conditions after the date of breach to assess damages. So the debate really centres around the use and permissibility of hindsight relating to situations where one is valuing an asset at a point in time. So this webinar is going to focus on those issues, those valuation issues. So, let's kick this off. Anneliese, can you please tell us what the overriding compensatory principle is under English law?
Sure, thanks, Jonathan. I think it's important to start with this because when we go on to look at all the various exceptions, I think they all come back to this principle. So what is it? The compensatory principle has been described as the overriding rule of damages and also as the bedrock of every assessment of damages. And in simple terms, it provides that where a party sustains loss by reason of a breach of contract or a tort, he is, so far as money can do it, to be placed in the same situation with respect to damages as if the contract had been performed. So in other words, you need to bear two things in mind when you're looking at any case. First of all, on one side of the page, you set out the position that you're in as a result of the breach or the tort. And then on the other side of the page, you set out the position that you would have been in if the wrong hadn't occurred. And I think that's a very useful starting point when we come on to look at some of the principles that we're going to discuss today. And I'd encourage everyone on the seminar today to start with that. Obviously, what you then have are lots of rules such as mitigation of loss, etc., that come into play, and we'll come on to talk about date of breach. But fundamentally, what a court or tribunal is trying to do is put you in the position that you would have been in if the wrong hadn't occurred. So that's in essence what that principle is. It's simpler to state than some of the other principles that we're going to come on to. But I think you find that in every decision maker's mind that that's what you should be doing. We obviously don't have a situation where you shouldn't be being compensated for loss you haven't actually suffered, or you wouldn't have suffered.
And Anneliese, that's why we have the other principles or concepts that you touched on, mitigation, causation, remoteness of loss. Most people on this call, I'm sure, will be familiar with Hadley and Baxendale, the two limbs test. Loss is only recoverable if it was reasonably foreseeable, or second limb consequential loss is recoverable subject to special knowledge that the parties had. And that's a helpful illustration of ultimately all of these rules are just to ensure that the injured party recovers no more than its actual loss. Those additional rules just provide the boundaries to the compensatory principle.
Great. That's, I think, obviously that's looking at the common law approach, and there'll be people from a civil law background and also who are dealing with cases that are involving civil law systems. How does the approach change, if at all, in civil law? James, can you talk to that, please?
Well, the first difference to bear in mind is that in civil law jurisdictions, specific performance is actually the primary remedy. Damages in lieu of performance is only a secondary remedy where, for example, specific performance may be completely out of all proportion to the breach. And this is the position in many civil law jurisdictions, both in France and Germany, for example. That's to compare with here in the UK and other common law jurisdictions where the primary remedy is, of course, damages, and specific performance is only where damages are not an adequate remedy. But when you do get to damages in the civil law jurisdiction, the assessment is also based on the compensatory principle, the idea of full compensation to put the injured party in the place it would have been had the contract performed as if the breach had not happened. So the starting point is essentially the same. Civil law jurisdictions also embrace the concepts of causation, the idea that the loss has to be caused by the breach, and also foreseeability. Concepts of mitigation are perhaps less well defined. But when I was speaking to some of my European colleagues over the last few days, I'm certainly no expert in civil law jurisdiction, so I cheated a little bit, but they suggested to me that the way to think of it is that the civil law courts have a greater discretion when it comes to setting damages. In practice, I'm told the French courts, for example, tend to focus on the degree of fault of the breaching party. The higher the degree of fault or willfulness on their part, the higher the damages are likely to be. And that probably won't surprise people with a short understanding of civil law systems where concepts of fairness and reasonableness play a bigger part than they do in the common law jurisdictions.
Yeah, I think that's my experience as well. I think fairness is a much bigger part of the civil law system. And so, for example, you see in some of the cases about damages that the court will look at what the contractual allocation of risk was, and even where it's quite unfair, won't intervene. Whereas you might find in a civil law system that's not. There will be more intervention to reach a fair result. So I think it's just degrees of emphasis and also the extent to which decision maker can interfere with the contract that the parties reached. David, I was going to turn to you and talk about how an expert sets about performing a valuation without the use of hindsight. So before we come on to muddy the waters with hindsight, how would you go about carrying out a valuation without using hindsight?
Well, I think both of you have mentioned one of the key issues, which is foreseeability. So when you're looking at doing a valuation, one of the key things to decide is what is the date that you're going to do that assessment of the value at. And then the important thing to do is to determine what information would have been available at that time. So what would have been known or reasonably knowable by the parties, i.e. what would be foreseeable. And that sort of takes two steps. There's that information that the company holds. So it's what did they have at the time in respect of what did they know about how they were performing, what did they know about forecasts, business plans, etc. going forward, and what did they produce at the time. And then you've also got market information. So you're looking at what were the particular conditions in the market at that time. So you could be looking at forecasts for commodities pricing, forecasts for inflation or for interest rates, or information that you think you know about the prices of your products or that company's products in the market. So the key is going to be what was foreseeable at the time of the date of the valuation. So when you get to that, then you've got to think about, well, how does the compensatory principle interact with the so-called breach date rule? So looking at that date, so Anneliese, what is your view on that?
Well, what you have alongside the compensatory principle is a rule, a general rule, that when you're assessing damages for tort or breach of contract, those will be assessed as at the date of breach. Now, that sounds a very easy rule to state. The problem is, in practice, what you have are quite a high number of exceptions. And we've also seen the Supreme Court in England expressing the view that that principle, that you assess damages as at the date of breach and you ignore what happens afterwards, cannot apply if that would give rise to injustice, or if it would offend the compensatory principle. So, for example, you've got cases where a contract's been terminated and subsequently war breaks out, and that would have allowed the contract to be terminated in any event. That's the Golden Victory case. And the court says, well, we can take that into account because otherwise you'd overcompensate one party. It's also the case that if you have a situation where a party terminates a contract in relation to an anticipatory breach, again, it's more likely that subsequent events will be considered. Thirdly, where you've got damages dependent upon a future contingency, which would have been estimated at the date of breach, but you know what the position is as a matter of fact by trial, that's a third situation where you may be able to take into account subsequent events, but be careful if there's a specific contractual allocation of risk. Under English law, it's very important that that will override what's actually happened. And then you've got a separate bucket altogether, which is damages for personal injury or an outright exception. But I don't think we need to talk about that too much today. I think one of the things that's important to bear in mind is that if you take the date of assessment as being the date of breach, so say none of the so-called exceptions apply, you still have to mitigate your loss. So you still have to go out and if there's a readily available market, you have to buy replacement goods, for example. And that's why there's been some recent case law in the Court of Appeal to say that this principle, date of breach, is really a rule of thumb rather than a rule of law. And I think the other thing that courts often feel is you shouldn't ignore what you know has happened. It may be that that's not relevant to the assessment of damages, but to ignore it completely, you have to have a reasoned basis for doing that. So I think the rule is easy to state, and I remember as a young lawyer just thinking, well, that's an easy rule, but then there seem to be all these exceptions. So what is the rule? It can be quite hard to apply in practice, but I think you need to bear in mind that the date of breach rule always has to be consistent with, one, the compensatory principle, two, contractual allocation of risk, and three, mitigation. So you have to have all those other principles that are going to come in and be considered, and then you have to try and work out from that where you're going to end up.
Yeah, the date of breach rule really does derive from mitigation, doesn't it? And there's so many cases dealing with the sales of goods where that provide the bedrock for assessment of damages. And in those cases, the injured party has a duty of mitigation, and so therefore has to go to the market to assess his loss. And it's assumed that they would go to the market at the date of breach, because otherwise they're risking changes in prices, what have you, into the future, and therefore that risk is not reasonable. And so therefore it's sort of grown up. Everyone assumes that you assess damages from the date of breach, but ultimately you have to go back to the compensatory principle, and you shouldn't assess damages at that point in time if it results in injustice, as Anneliese said. And here I think a quote is very helpful. Lord Bingham was quoted talking about the Golden Victory case, and he said, "You need not gaze into the crystal ball when you can read the book." And the point there is why should you make assumptions when things have become known, facts can readily be assessed that will help arrive at the fair compensation.
Yeah, although the Golden Victory was a 3-2 decision, as it just says, even in the Supreme Court, they can't actually necessarily decide what should be taken into account. So don't beat yourself up if you find it somewhat taxing to work out. And the number of cases that continue to go through the higher level courts about this issue does show it can be quite challenging. I think this thing about market and mitigation, though, obviously that assumes there's a readily available market. And again, talking about COVID, I think it will be very interesting because in a COVID situation, what is the market? Who knows what's going to happen? How do you mitigate in COVID? So you may have those additional complications coming in. Mitigation may not be as easy an argument when there's such uncertainty.
Okay, before we move on, there's a couple of questions that are probably quick to deal with that have come in from the audience, certainly from a civil law lawyer. He asks, is there no concept of causation or foreseeability in common law?
Well, the answer to that is yes, those concepts are very important, fundamental to civil law. To common law.
Yeah, they are. And we also have scope of duty, which is an additional thing that can be applied. So you can see some losses are not deemed not to be recoverable as a matter of law, just to make it even more complicated. We also have legal causation and factual causation to deal with. So yes, the answer is yes, but I think we're trying to keep it as simple as possible. But again, ultimately, you're looking at what's legally relevant or legally relevant from a causation point of view and what's not.
And then the other way, is there never an issue for a judge under English law of fairness or reasonableness?
Well, yes, there is fairness, perhaps not, but certainly reasonableness. Again, Hadley and Baxendale may be familiar to a lot of people on the call, but the idea is that losses are only recoverable if they were reasonably foreseen at the time that the parties entered into the contract. And mitigation also brings into play issues of reasonableness in terms of what the injured party does in response to the breach. They have to act reasonably, and they can't do anything that might increase their loss. So the reasonableness certainly does come into it.
I think the big difference, though, is that that's absolutely right. Those principles apply, but what you can't do is apply. You can't rewrite the contractual bargain that's been reached. Whereas I think in civil law systems, there's more flexibility to potentially strike out provisions that are unfair. Whereas in English law, that's very limited. We obviously have some statutes for unfair contract terms. We also have an interesting position on good faith, traditionally not allowed, but there's a particular judge who's now in the Supreme Court, Lord Leggett, who's developed a sort of jurisprudence. For example, in relational contracts, so long-term contracts, you may have duties of good faith imposed. In the post office litigation, which was very high profile, the judge imposed duties of good faith. So I do think that's also going to be an interesting area to see, and that obviously could impact on damages significantly.
Okay, moving on, we talked about where you're not you're supposed to use hindsight. But are there instances where hindsight is allowed?
Yes, there are. And I'm going to continue the theme of referring to some very old cases. The one example that I'm going to use is called Balfour and Merthyr Deerstream Collieries, and it's from 1891. And it was a claim for loss of profits on a mining seam, which the claimant was prevented from assessing by the local waterworks. And in that case, the court allowed the assessment of future lost profits to take into account the fluctuating coal price over the time up to the date of the arbitration. So the post-valuation date transactions provided an ex-post certainty over the conditions and value that were being assessed at the valuation date. And here I'm going to use another, what I think is an excellent quote from Lord McNarton in that case. Apologies if I got that pronunciation wrong. I think perhaps I did. He asked, talking of the arbitrator in the original case, he said, why should he listen to conjecture on a matter which has become an accomplished fact? Why should he guess when he can calculate? With the light before him, why should he shut his eyes and grope in the dark? And I think that kind of sums it up. Why should the valuer assessing the value of lost profits not take into account what the coal price did in the following months? That merely just achieves greater certainty, ensures that the injured party is only compensated for its actual loss. And as we've talked about, that's what the compensatory principle is all about. There's also more recent case law to suggest that hindsight based on actual performance after the valuation date may be permissible in order to confirm what forecasts could have reasonably been made at the valuation date. So when valuing an asset, it's obviously accepted that prior share transactions, prior dealings may be relevant and given a very strong weight in valuation, but you should be aware that subsequent transactions may also be considered and may be a weight in assessing profits or in assessing underlying assumptions, provided, however, that nothing significant has changed in the business and its market in the meantime. If the business has moved on, if subsequent transactions involve special conditions or perhaps a special buyer, hindsight is unlikely to be accepted because those unique characteristics can't have been assumed at the valuation point. So fundamental changes in circumstances will make it more difficult, I think, to use hindsight. Significant changes in market dynamics mean that future events are not necessarily a great guide to the reasonability of assumptions. So black swan events such as COVID that disrupt the markets, that they may actually operate to restrict the use of hindsight.
Yeah, I mean, I think what's important is if you want to rely on post-breach events, that you have to plead and prove them if you want them to influence a decision maker. And you also need to think about how you're going to say they're necessary in order to give effect to the overriding compensatory principle. Third caveat, one thing that has come up is if there's dishonesty, you can't rely on them. Perhaps not surprisingly, but that is one of the principles that runs through some of the cases. So I think you need to think about how you put it. I think in relation to how the impact of COVID, it's all so uncertain that my own view is that it's worth having a go if you can fit it in within the general principles on the basis that COVID would have happened and would have affected. But it does raise real issues, particularly when the parties haven't catered for it in their contracts. And what's interesting is that in English law, unlike some other jurisdictions, so in the DIFC, again, there are specific provisions dealing with force majeure, etc., even if it's not in the contract, whereas we just don't have that. But yes, to date, a lot of people have been resolving their disputes arising out of COVID amicably. But the longer it goes on, we'll see if there's going to be, you know, any more interesting decisions coming out, hopefully.
It's not going on any longer, is it? I thought it's all coming to an end, COVID.
Who knows?
So David, a question for you. How does an expert assess damages if there is little or no contemporaneous forecast from around the valuation date?
It's one of the sort of more difficult things that that experts sort of come across, where you have maybe a business that's got no track record, or it doesn't have those forecasts for the relevant time, or the forecasts that have been prepared are so out of date by the time you get to the date of assessment. So you may have an issue that's arisen on the 30th of November, and the forecasts that you have are for the whole year, and they were prepared the previous October, November, so they could be a whole year out of date. So you've got to look at that information that was available close to the valuation date, or even look just after the valuation date. So in that example where you're assessing damages on the 30th of November and the year end maybe 31st of December, you may already have the forecasts for the following year that are prepared around the November date, or even sort of into December. So you could start to take those into account if those forecasts are on the basis that whatever that you're claiming for, the breach, hasn't occurred. You also need to look at sort of quite detailed how the business has been performing, especially in the lead up to any date of assessment, what the market conditions were for the particular industry, and what was known about the macroeconomic sort of factors at the time, and also looking at some of the comparables and maybe those sort of businesses which are similar, and looking at how they were expecting to perform going forward. So you may have public companies who are in the same space as the company that you're looking at, and they have some forecasts which may be out there in analyst reports that will give you some indication of how people are expecting the market and the industry to change over time.
And Jonathan, then over to you. Flip side, if hindsight is allowed, how do you incorporate that?
We can't hear you, Jonathan.
Goodness, it's always going to be me
Yeah.
who did it first, isn't it? How many times has that happened this week? So, I mean, in theory, this should be more straightforward than forecasting a future scenario, as you can factor in the effects of known events into your calculation. But you then consider, the outlook, and well, you consider the actual performance and the actual market outlook, but then you sort of get to look again at the date of assessment of what the future looks like as at that date. So you can also say, using hindsight, you're taking some of the future possible variations out of it, because you are using more up-to-date assessments of what the future may look like.
You're reading rather than looking at the crystal ball.
Exactly, but you're sort of looking at a crystal ball at a later point in time. So that should be, you know, if you're using hindsight for 2 years, then after 2 years, you'll then should have more accuracy on what the future should look like at that point in time. Rather, if you're going back to the date of breach, your expectations of what might happen in 2 years' time to the 4-year time period can be off because of different events. There can be more of a separation of fact from expectation. So what you then get to obviously use by using hindsight is considering the macroeconomic events, such as looking at inflation and commodity prices, but also the microeconomic events which can have a specific impact on a company or industry, such as changes to cost structure, products, sales prices, different trends that can occur over time, and new product development. So this information is available from economic indicators, from industry and sector analysis, the performance of competitors, and also the company's own financial performance. When using Hindsight, you have to make sure, though, that you consider all the sort of interplay of the different impacts and don't just think and focus on one element in isolation. So, for example, from a macroeconomic event, if there's increased inflation, that would actually lead to potentially increases in profits on a standalone basis, as sales prices would increase and your cost base would potentially increase, both in line with inflation. If that happens, then actually the profitability of the company is going to increase, because there's, again, a divergence. If you're increasing a larger number by, say, 5%, and a smaller number by 5%, you actually increase the profit by 5% as well. So if, for example, and I had this matter recently, you're looking at a damages claim actually in a different currency, you then have to step back and say, well, what would be the macroeconomic effects of a rise in inflation? So where there's a rise in inflation, if you're looking at, say, different currencies, there's actually likely to be a devaluation of that currency against the currency you're actually looking at. So that may well take out any impact you see from inflation. So you really just need to sort of just step back and make sure you consider the wider economic impacts.
So the next question I have here, I think perhaps sums up some of what you've said, and is perhaps more of a statement than a question, but where you have a date for the assessment of damages after the date of breach, can one treat the but-for scenario up to the date for assessment as being certain, well, being more certain because of the application of hindsight? The answer there is yes, I presume.
Yeah, I mean, it depends whether you're talking about certain or more certain.
Yeah, more certain.
Yes. So if you're talking about certain, obviously not.
You can never be 100% certain, right?
Exactly.
Yeah.
And you know, just sort of talking about this, you can see that it's going to be a very complex question. So when you use hindsight in a but-for scenario after date of breach up to a date of assessment of damages, accuracy should increase over that period. It can't be considered certain, but as you say, it could be considered more certain. So no matter what in a but-for scenario, there's still going to be elements that require estimation. So if we're looking at a sort of the cash flows and how you should treat them in a period between the date of breach and a date of assessment, there are two schools of thought. One is firstly that you assume that damages after that date of breach are estimated and then apply interest to those up to a date of assessment. So that's effectively saying that you're treating them as certain. Or secondly, you can discount the damages back to a date of breach and then apply interest on the amount up to the date of assessment. But where discount rates are higher than applicable interest rates, which is generally the case, the first scenario would result in a higher damages figure than the second scenario. So in the first scenario, the interest rate which is used is generally above the risk-free rate. It'll be a risk-free rate plus some percentage points. Therefore, if one assumes that the premium above the risk-free rate accurately reflects additional risk, then in effect one can justify the application of just applying interest to the cash flows, because it has the same impact as discounting back at one rate and then inflating at the same rate. In the second scenario, if it's decided that risks are greater than the risk-free premium, then it would be appropriate to discount back to the data breach and then apply interest. However, the consideration here centers around what is the appropriate discount rate to apply in periods where hindsight has been used. Now, valuations, particularly the calculation of discount rates, are designed to be forward-looking. Therefore, the commonly accepted approach to calculating discount rates, being calculating the weighted average cost of capital, does not work for risks on historic cash flows. This is because many of the risks which a WACC allows for will be known where hindsight's used. For example, hindsight would tell us where what actual prices were, what actual cost bases were, and therefore those risks are removed. So no one has yet produced, however, a model that helps you calculate the discount rate for historic periods. So it becomes a very subjective area and an area of contention between experts. And this subjectivity will lead to similar arguments as we see around inputs such as control risk premiums and discounts for lack of marketability. Now, there's little case law at the moment to help us actually with this, unless you look at, for example, I mean, there was a recent High Court case, which is Lilly Icos against 8PM chemists, where as it was IP and as the product had not gone to market, the judge decided that it was appropriate to apply a discount based on the percentage chance of the business going into liquidation. However, this is obviously based on a very specific set of circumstances, which is not really applicable outside of that scenario. For example, if you're looking at damages for a shell, it's very hard to say, well, what's the chances of that going into liquidation in this year? So it doesn't really translate outside of that area. In our experience, in most cases we've looked at, there are many cases where claimants treat cash flows as certain and respondents say they aren't certain and then look to apply the weighted average cost of capital. So, you know, that will obviously have a big swing on the quantum of damages. I think if you sort of think about it sort of logically, the answer will possibly sort of fall somewhere in between the middle, between a risk-free rate and a WACC. And I think there's going to need to be a lot of discussion and thought around that if hindsight does become more prevalent as a result of COVID or other issues.
So I think from what you're saying, Jonathan, you don't think the same discount rate or the same approach should be applied to past damages as opposed to future damages, that there should be different considerations which apply to each. Is that right?
That's right. I mean, yeah, the simple answer is I just don't really see a situation where you would apply the same discount rate, because, you know, many of the risks which a forward-looking discount rate will take into account just don't exist in a but-for historic scenario where, as I said, mentioned, you know, you can know what prices are, you can know what input costs are. You know, a lot of the impacts on your but-for position will sit around probably sales volumes, for example, and the risks that you take into account in forward-looking just aren't necessarily appropriate just looking at that sort of one element in isolation. So in effect, by using hindsight, you're de-risking the risks that are inherent in a weighted average cost of capital. So just trying to get my voice back. James, if we are sort of looking at, you know, are there different considerations in a BIT expropriation scenario that need to be taken into account?
Yes, there are a couple of considerations. First, I think it's important to distinguish what has become to be called legal and illegal expropriation. So most treaties prohibit expropriation unless the expropriation is undertaken for the public purpose in a non-discriminatory fashion with due process and upon the payment of prompt, adequate, effective compensation. So treaties often use exactly that language to define what may be called legal expropriation. And given this concept of prompt, adequate, and effective compensation, it's generally accepted that the market value of the expropriated asset should be, at the time of the expropriation, is to be paid as damages. So hindsight is not usually applied, and an ex-ante approach to valuation is used. However, things get a little bit more complicated when we're talking about an unlawful or an illegal expropriation, and that's one that's not in the public good, is discriminatory, made without due process, and for which compensation is not paid. And tribunals in that situation have looked past the concept of prompt, adequate compensation and taken their cue from another very old case called the Chorzów factory case. And it was a case between Germany and Poland involving the expropriation of a nitrate factory. Poland was held to be in breach of its agreement with Germany for having sold the factory. And in response to that breach, the Permanent Court of International Justice set upon what has been described as the full reparation standard. Reparation for an illegal act. And here again, I quote, must so far as possible wipe out all the consequences of the illegal act and establish the situation which would in all probability have existed if the act had not been committed. And this tribunals have sort of developed that as a disgorgement remedy. It focuses more on the state's conduct, the illegality of its conduct, and seeks to ensure that the state takes no benefit from the expropriation. So arguably it moves a little away from the compensatory principle. But the problem with that is, of course, for the claimant, that can cut both ways. Obviously, an ex-post valuation may be significantly better for the claimant, but it can also be significantly worse. So authority is perhaps not the right word in the context of treaty arbitration, where cases don't have binding authority, but the jurisprudence at least has developed to suggest that the claimant may choose the approach to valuation which best suits it. And the UCOS case under the Energy Charter Treaty is one very high profile case which adopted this approach, which had an effect in the several billions of dollars. Now, this is of course an oversimplification. There's many cases on these questions and many prominent dissenting opinions. But just to conclude, I think probably what is most certain is that this issue is going to face greater scrutiny given the increasing criticism of treaty arbitration and the growing thought that it overly favours the investor to the detriment of states. So I think this is a debate that's going to continue for some time.
Yeah, I mean, I think, yeah.
Go ahead, Anneliese.
No, I was just going to say, I think when I first started doing investment treaty cases after having been in English court, it was like being in a sweet shop because there were so many options that you could go for and you could really use a bit more creativity. But the downside of that is there's a lot more uncertainty, and you certainly see enormous claims being made sometimes. And no one knows what the outcome's going to be, and so many permutations put forward. But it'll be interesting to see how that develops.
So do you think claimants should be sort of presenting alternatives in their sort of claims, a date of breach calculation as well as a date of assessment calculation, and should the experts also be doing that to help the tribunal, so they've got two sort of points to look at?
I think
Yeah,
probably. Sorry, I was just going to say you should probably certainly do that in the background, but whether you actually present the case will depend very much on the strength of those alternative arguments. There'll be strategy decisions around why you might or might not do that, depending on the given case and the particular claim and assets in question.
Yeah, I think that's right. I mean, I think there is a distinction there between the case being presented by lawyers and the experts, though. I mean, one of the ways in which I successfully attack experts is when you act on the basis of assumptions that are all pro one party's case. So I think as an independent expert, you do have to be a bit careful that you're seen to be being balanced in terms of assumptions that are made, and sometimes you may need to make a wider variety of assumptions than perhaps you're instructed to do, or at least talk to your instructing party about that, because in the long run it may benefit you as appearing as a credible expert, which I know, David, you do. Challenge your those instructing you, but that's a good thing.
And where you are not supposed to take hindsight into account, is it in reality, are arbitrators and judges really sort of just ignoring what happens afterwards? So if somebody was looking at a claim on the 31st of December 2019, would they not be influenced by what has happened since?
I mean, it depends. I think the reality is most people in commercial cases will be somewhat influenced, even if not directly, subconsciously. It may affect the amount that's awarded, because there may be some difficult decisions to be made, and as a matter of law you might have to make one decision, but you might be more generous in another area. I mean, I think people always forget that the decision makers are human beings. So you have to appeal to someone as a human being. You can have the best legal arguments in the world, but unless you appeal to them as a human being, you're not going to do the best for your client. There are some examples, particularly in English court, where it's been said this is actually irrelevant, and it can seem quite harsh. Like there was a recent case about someone who'd suffered an injury, and actually the injury turned out to be not as bad as had originally been thought, but he could still sue his solicitors for what he would have got if they'd acted competently and made a claim for compensation. So it's quite interesting. Sometimes there are hard decisions like that, but I think in a commercial context, it's definitely worth running these arguments if they're credible, because you never know how it may affect the overall amount awarded, is my view. And likewise, if you're on the other side, you have to bear and take into account how you diffuse that if it's being used against you.
Yeah. I think that's the point you made earlier when I was saying that perhaps black swan events like COVID make the use of hindsight more difficult, and you said yes, but it opens the possibility for those arguments, and this is why, because tribunals are humans. Sometimes they might not appear to be, but they are, and these things are very, very hard to put out of your mind. I mean, COVID, it just pollutes every thought. So yeah, it is going to sneak into decisions and have influence where, strictly speaking, perhaps it shouldn't.
Yeah, I mean, talking about black swan events, Jonathan, how do you take account of those when you're carrying out your valuations?
I mean, I think the key consideration is obviously whether they should be taken into account as a first point. I mean, just by their definition, these are sort of unpredictable events which are beyond what is normally expected of a situation and of potentially severe consequences. They're characterized by being extremely rare. And I mean, just looking at COVID, let's sort of think about some potentially comparable global pandemics. We had the Spanish flu back in 1918. We had smallpox in Europe in the 1800s. The original bubonic plague back in sort of 1350, around there. So you can see that these are certainly not considered to be regular events. There's obviously smaller impacts throughout there, such as SARS, etc., but they had they really can't be considered to be black swan because they did not have the global impacts that we're seeing here. Therefore, it's sort of difficult to justify the inclusion of potential future black swan events when performing evaluation. Saying that, so going forward, there may be elements of COVID which are intrinsically built into valuations for the next sort of period of time. For example, in discount rates, the equity market risk premium will likely include some risk associated with COVID as it's based on historic returns. So the easy solution, though, is just to sort of take that information you're provided with. The more difficult route would be to consider trying to reperform actually an equity market risk premium and taking that out. So when performing valuations post-COVID, I think the interesting piece will be how the experts decide to deal with its impact on past performance. As David mentioned earlier, normally historic performance is used as one indicator of future performance. So where there are seismic events such as COVID, there's obviously justification to remove that impact from the period that you're analysing on the assumption that it's a non-repeating event. And if it's not removed, then sort of future expected performance could be unfairly negatively impacted. This, however, obviously assumes that a company will return to pre-COVID performance. What if there is a new normal? In such a situation, you can't really consider past performance at all. So I think it will need to be considered on a case-by-case basis. And we haven't seen too many of these coming to awards to date. So we don't really have guidance for the courts on how it's treated. So I think really it should be excluded. It's just whether you can exclude it in its entirety and how you'd go about that.
We've got a couple of minutes left, and there are quite a few questions that we haven't managed to get to that have come in from the audience. So I suggest with the questions from the audience, we will respond over the next few days. We'll pull together some responses to those different questions and send them out to those that asked the questions. But there's one question that could be answered quite quickly, I think. Are there any reasons why hindsight can't reasonably be used in cases where there's minority oppression?
Maybe it's not that easy, David.
Yeah. No, I mean, I think, again, you just need to bear in mind the general principles that we've been talking about. But I don't think minority oppression hasn't been in a special category so far as I'm aware.
And there was one other question about talking about what Jonathan was talking about basically discounting future or discounting historical losses. Do the English courts find it acceptable that you treat historical damages as certain and you just add interest to them?
That's the general approach in courts, yeah. But, well, obviously, by the time you get there, you should know what's happened. It depends what date you're using for assessment as well, because if you are using data breach as a cutoff, right, so you don't actually even consider some past events. But yeah, generally in courts, discount rates apply for future loss, not past loss. But you can have other contingencies taken into account that might discount damages in a different way, but probably not through a discount rate.
Great. I think that's all the time we've got for questions. John, do you want to do a quick wrap up?
Yeah, well, I mean, we're up to the hour mark, so I think I'd really like to thank everyone for joining us. As I say, we very much appreciate your time joining us this morning. I mean, I found Anneliese and James's comments extremely insightful and you know, improving my background on the legal case for it all. And hopefully, we've added some elements of knowledge around the numbers between David and myself. As David mentioned, we'll have a look at the questions that we actually unfortunately didn't get to, but there were some great questions there, and thanks for those. And I hope you enjoy the rest of the day and look forward to catching up soon. Excellent. Well, thanks, everybody.
Thank you, everyone.
Thank you. Thanks, everyone.